Good afternoon or good morning, depending on where you're joining us from today. I'm Nancy Barnes. I'm a labor and employment partner and head of our labor and employment practice group at Thompson Hine, and I'm based in the Cleveland office. Welcome to today's webinar. I'm delighted to introduce three other labor and employment colleagues who are going to be presenting with me today. We have Scott Young, who's a partner in our Cincinnati office. I'm also joined by Debbie Brenneman, who's a partner in our Dayton office, as well as Hannah Caldwell, who is an associate here in Cleveland. For the next 75 minutes or so, we will be reviewing the latest developments that human resource and employment professionals are facing as state and federal authorities revise their guidance regarding workplace safety and the interaction that employers have with employees as they come back to the workplace. And we will also be addressing issues that employers are facing with the reality of a hybrid workforce. I will also provide a brief summary of a recent survey that was conducted among our clients and contacts on this subject. Due to the large audience we have on this call and the amount of content that we are presenting, we may only have a short time for Q&A at the end. We encourage you to put your questions in the chat box and we will address them with whatever time we have remaining. We encourage you to contact your Thompson Hine lawyer with any follow-up questions you may have after today's webinar. To proactively answer a question we receive frequently, we will be recording today's webinar. We will send the recording and the presentation slides to all registrants within the next 2 business days. Thank you for your interest, and we will now begin the webinar. So we are talking today about returning to the workplace, which is a hot topic. I think I have seen an article about this in the Wall Street Journal almost every day for the past 2 weeks. So everybody is thinking about this and talking about this. And so we want to talk a little bit about what employment looks like post-pandemic. So here's the agenda of topics we're going to be touching on today. First, we'll be reviewing the employer survey that many of you may have participated in and talking about the results of that survey. We'll also talk about employment challenges post-pandemic. That will be followed by a discussion of vaccines, where the CDC stands, and Osha. We'll talk a little bit about vaccine litigation, which hopefully none of you are involved in. We will talk about ADA and religious accommodations, as well as remote working concerns, as that's going to be something that most employers are addressing in the future. We'll also talk about the FFCRA, where that stands in 2021, as well as the status of state anti-vax statutes. So first, let's talk a little bit about this survey that Thompson Hine conducted. And if you participated in this or received it, you know that when we had the survey open, it was right at the same time that the CDC was issuing its new guidance. And so these results, I would say, are a mix of results coming from people who answered both pre-CDC guidance and post-CDC guidance. So it's a little bit of a mixed bag. And I think, frankly, if we sent the same survey today, we'd have slightly different results. So first, let me just tell you a little bit about the respondents who participated in our survey. As you can see from this slide, we had employers of widely varying sizes responding to the survey. The biggest group were employers between 51 and 500 employees, but we had a significant number of smaller employees as well as those with more than 10,000 employees. In terms of geographic scope, it was relatively evenly split with regional companies and organizations, as well as those who are based solely in the United States, and then also nearly 30% having some sort of global footprint. So it's, again, a pretty broad array of organizations who responded to the survey. So current working conditions, we wanted to get a sense from people about whether or not their workforce had essentially been open throughout the pandemic, had been closed, partially open in some way, or open with a rotating schedule, which is what that light blue bar is at the bottom. And as you can see, nearly 30% of the respondents have been open, completely open basically this entire time. Whereas the most popular response with over 50% of our responses were partially open. So some employees reporting to the workplace, others working remotely. So one of the questions we wanted to ask was sort of what the workplace was likely going to be looking like after August 1st. That's a deadline we chose sort of arbitrarily. A lot of companies are talking about the possibility of kind of quote unquote getting back to normal by that August timeframe. So we just sort of arbitrarily chose that date and asked people to tell us, what is the teleworking situation going to look like based on their estimates as compared to pre-pandemic? So about 40%, this is for full-time teleworking, about 40% said it's going to look the same pre and post pandemic. But there was also a significant number of respondents, 60% in total, who said there's going to be an increase in the full-time workforce working remotely. And so the vast majority of those people said a 1 to 50% increase, but there were also significant numbers who are seeing 100% increase or over a 200% increase. In the part-time realm, you see that, again, there are some significant changes that employers are expecting in terms of how many workers will be teleworking part-time. And I think this is the number that we're going to continue to see change on as people figure out how to deal with a workforce who, as you'll see in some later slides, is going to be demanding that flexibility and the opportunity to work remotely at least part of the time. And so here we see about 33% said that they don't expect any sort of change pre versus post-pandemic. A significant third say they expect a 1 to 50% increase in part-time teleworking. You see close to a 20% who are saying a 51 to 100% increase, and then significant numbers saying more than that. Vaccination status. Now, this is a question that I would expect we would see a slightly different response on today. Again, just given the percentage of people who are vaccinated and what the CDC's guidance has been with respect to vaccinated employees. But this question was asking, are you requiring your employees to share the information? And you can see less than 10% of our survey said, yes, we're requiring people to share their vaccination status. Slightly more than 30% said we're encouraging it. A little more than 10% said that they're conducting surveys that are anonymous. And then close to 50% said, no, we're not asking about vaccination status. And again, this survey was conducted in mid-May. And again, this is another question I would expect that the answers might be different today. Do you have policies that make distinctions between vaccinated and non-vaccinated employees? And you can see at that time, maybe about 5% said yes. The vast majority of people, over 60%, said no, but we're currently thinking about no, and we currently don't intend to have those. And then the yellow bar is no, but we are considering those changes. So that was about 35% of respondents at that time. And again, I would expect that both the yes and the no, but we're considering it bars would be much larger today. Have people asked their employees about their thoughts or feelings of returning to the workplace? This was about 50-50, about 50% had said, we did some sort of survey, about 50% said that they had not. We asked people about the ongoing precautions that they intend to use with employees even after vaccines are readily available, which in most parts of the country, if you want to be vaccinated and you're an adult, it's readily available to you. And so a significant number of employers are still talking about wearing PPE in the workplace, physical distancing, limiting group gatherings, conducting increased cleaning and sanitation. The vast majority of respondents said that those things are going to remain in place even after vaccination. So let's talk a little bit about what I referenced when we started the webinar, which is some of the articles that I'm sure we're all seeing in the Wall Street Journal and other publications talking about what is the workplace going to look like post-pandemic. So hybrid work, is this going to be the new normal? That's the question that everyone is asking and thinking about in terms of hybrid work. And by hybrid work, what we mean is having a workforce where a significant, it doesn't have to be a majority by any stretch of the imagination, but a significant portion of your workforce is either working at home full-time or potentially part-time and coming into the office or workplace on a part-time basis. And people are considering, how is this going to work? Does it work? Is this something that you're essentially going to be required to provide as a possibility in order to recruit and retain certain employees? A lot of industries are seeing a significant amount of turnover and demand, either from applicants or their current employees, about what is the requirement going to be in terms of being physically in the workplace as opposed to being able to work remotely. Headhunters are reporting that recruits are basically saying, don't even send my resume to companies that will not allow me to work from home, at least part-time. So the battle for talent, potentially in certain industries, is really going to potentially turn on this issue and how successful employers can be in terms of providing flexibility that maybe their applicants or employees are demanding. Another big challenge for employers, and we were all kind of forced into this social experiment over the last year, is how do you manage hybrid work? How do you manage remote employees? We certainly had managers and supervisors who had never had to deal with this situation, to be managing people who they didn't sort of have in front of them day in and day out. And I think that this is something where companies are really going to be able to set themselves apart if they can figure out, how do you successfully do this, and how do you collaborate, and how do you build a culture, and how do people feel tied to a workplace that maybe they're never actually physically going into, or they're going into only on rare occasion. And then another thing that employers are thinking about is, what do we do with our office space, workspace? Do we need as much? Should people continue to have assigned offices? Should we be reconfiguring our space because people are really kind of only coming into the office in order to do meetings or collaborate? Do we really need all of this sort of individual workspace? How do we manage the space that we have? How do we downsize the space that we have and then manage the demand for the space that we retain? You know, these are all questions that companies are dealing with. So there's also an array of views on hybrid work. Obviously there are some jobs or organizations, that remote work is not a possibility. And for certain roles within an organization, it's really not possible to do those either part-time or full-time away from the workspace. But for those organizations where there is that possibility, and you've had employees who have been working remotely throughout the pandemic, these are questions that they're going to have to face as an organization. And if you, again, follow the news, you're seeing a lot of high-profile CEOs come out sharing what their particular views are on this, what their expectations are for their organization. Jamie Dimon of JP Morgan has said that he expects that nearly all of his bank employees will be returning to the office full-time. Google and Apple have said that they're going to go to a norm of 3 days a week in the office. Twitter and Facebook have said that they're offering full-time remote options. And then the Netflix CEO, Reed Hastings, has said working from home is a definite negative. So, you see just with these sort of high-profile companies, people who have thoughts all over the place in terms of whether or not remote working is possible, if it's a good idea, if people can be successful, if it impacts their organization. Now, not surprisingly, employees have other views. So I just gathered some information from some recent surveys that were done. Accenture did a survey. 83% of employees viewed hybrid workplaces as optimal. Ernst & Young, 16,000 employees. Of that survey, 90% of the employees wanted flexibility about when and where to work post-pandemic. Now, does that mean that all those people want to work 100% at home? I highly doubt it. But the point is having some flexibility, the potential for teleworking, that is going to be significant. Even more significant, and the thing that really jumped off the page at me from that Ernst & Young survey was half would consider quitting if they do not have flexibility. I mean, that is, for anybody who's in the recruiting and retention piece of the HR function, or as a manager trying to make sure that you're able to staff your function, that is an extremely scary statement if your organization is considering, everybody's got to be back 100% 5 days in a week in the office. That's certainly something that I would consider as part of any sort of decision making. A PwC survey of more than 1,500 employees found that 25% of those employees were considering a move more than 50 miles away from their home office space, which would suggest that they're thinking they're probably not going into the office 5 days a week. And 12% had already moved to a location more than 50 miles away. So again, when you think about commuting, work-life balance, I mean, these are things that employees, over the course of the last year have had a long time to think about and really experience. And so their views are remarkably different from what you would see pre-pandemic. Obviously, work-life balance is a huge part of this. And so, many employers are listening to what their employees are saying. And one of the things that's interesting too is that these are not just the millennial employees or Gen Z employees. It's not just the younger segment of the workforce that is driving this. You have baby boomers, Gen Xers who have suddenly said, wow, my life is a lot better when I'm not spending 10, 15 hours of my week in my car getting to and from work. So this is a sea change, in my opinion. In a survey that was done by recruiting agency Robert Half, 60% of employees stated that their work-life balance had improved because they're no longer commuting. Again, this doesn't seem like a huge surprise to me. Okay, so what are the challenges of hybrid and remote work? Obviously, managing remote employees, one of the things, and this is something, I think companies struggle with just in general, and this is just going to exacerbate the situation, is training managers on how to manage people. They are going to have to use different tools if you're thinking about a hybrid workforce in terms of communication, staying connected, finding ways to maintain the culture. And then retention is really a two-sided coin. On the one hand, you hear applicants and employees saying, if I don't have flexibility, I'm leaving, I'm quitting, I'm not taking the job. On the other hand, if people are so disconnected from their workplace, what sense of loyalty are they going to have to the organization? Are they going to feel connected? And are you going to have a greater risk that they pick up the phone from your competitor and the competitor offers them $5,000, $10,000 a year, and they're going to be able to work at home? They're like, sure, hey, why not? Because I don't really have relationships or connections to my current employer because I'm working at home 5 days a week. Advancement is something that a lot of organizations are thinking about and concerned about what is going to happen if they have a workforce that is, some people are in the office 5 days a week, some people are hybrid, some people are permanently essentially work at home and never come into the workplace. Are there going to be concerns of sort of two different tracks, second-class citizens? How is that going to impact advancement and development? Is there a stigma associated with remote work? Do you have certain populations who are choosing remote work more than others, and then that potentially impacts your diversity of the workforce that's being considered for advancement? There have been some studies previously, pre-pandemic, that showed that advancement was actually equal among people who worked remotely versus people who were in the workplace, but that pay increases statistically were less for those who were working remotely. PwC has come out and talked about what they're going to be doing. They are tracking advancement and development of employees who fall into these different groups, because from their perspective, remote working is just, it's not the future, it's the present, and they're just figuring out how are we going to deal with it, and they're committed to tracking it on a regular basis. Some things that other employers are thinking about is how do we conduct meetings? When some people are in the office, some people are remote, do we require everybody to essentially dial in like from a remote location, even if it's their individual office in the workplace, so that everybody is on a screen as opposed to some people being in a conference room and some people being on a screen? Some organizations have put in place rules about how these meetings happen when some people are remote and some people are present. They bar side conversations that the people who are on the screens can't hear or can't participate in. And they take steps to make sure that everyone is being able to participate equally. Some organizations are talking about having a permanent day in the office. So regardless of whether you have a part-time teleworking arrangement, everybody's in the office, you know, barring some vacation or commitment to a client or something like that. Everybody's in the office on Tuesday, or everybody's in the office on Thursday, so that they can still try to maintain that cohesiveness and have a day when you know that everybody's going to be there if you're trying to schedule meetings or that sort of thing. Productivity. So some executives have said that, you know, they see this whole remote work, hybrid work as being for employees who really don't want to hustle, who really aren't committed to the organization. And so some of those beliefs, whether they're founded in fact or just sort of, hey, this is the way it's always been, you know, dealing with those preconceptions and things of that nature is going to be something that any workplace that's dealing with a significant portion of their population teleworking is going to have to think through. Now, one of the things that's interesting, you know, so many people sometimes, I would say pre-pandemic would say, hey, these people who work at home, who telework, you know, they're working, and they use their air quotes as like, you know, right, they're kind of, you know, mailing it in on the day that they work at home. But there was a study from Protascore, which is a software company that does sort of monitoring of employee productivity by using email and cloud-based tools. And they found, I don't think really surprisingly, that employees were actually more productive in 2020 than they were in 2019. So I think there's probably going to be a lot of evidence developed that shows that teleworking can be quite productive. The problem just may be with some of these other issues in terms of collaboration, development, mentoring, connectivity, teamwork, some of those softer things that are harder to measure. That's, I think, where the rubber's going to hit the road in terms of how do we do this going forward on a more permanent basis. Okay, so other post-pandemic policies and considerations that lots of employers are thinking about. Obviously, a teleworking policy. I mean, most people, if they had a policy before, it is so woefully out of date that this is definitely something that you, if you haven't done it yet, you should really be looking at. And Debbie's going to talk a little bit about some of the pitfalls and considerations for employees who are teleworking that you might want to incorporate into those policies. Dress code is something that a lot of organizations are looking at. You know, people have been working in their pajamas, believe it or not, for the last year. And some people are really, you know, wedded to their yoga pants or not wearing shoes or whatever. I'm not necessarily advocating for a pajama policy, but you know, a lot of organizations are looking at, do we really need jacket and tie Monday through Thursday, or are we going to go to a business casual, or even something that's even a little bit less than business casual if you're not meeting with a customer or something like that. So that's certainly something a lot of people are looking at. Obviously, office configurations, rethinking their space in their existing office or workplace and how it may need to be adapted to sort of the way that people are working or when they're working. And then also a lot of organizations are looking at, I mean, a lot of people are balking at these commutes that they haven't had to do for the last year. And so some organizations are looking at flex space types of spots and more in the suburbs where people can, travel 15 minutes and be able to be connected to their office or have a meeting or have a conference room and that sort of thing. So now I will turn it over to Scott Young in our Cincinnati office so that he can talk a little bit about what has come out from the CDC and sort of what we have been seeing from Osha most recently with respect to the pandemic.
Sure, thank you, and hello everyone. I'm going to, as Nancy just mentioned, I'm going to speak on CDC, the recent guidance, just so that we're all on the same page in terms of what we're talking about today, and then that aspect of OSHA and how it has responded to the CDC guidance and what else it is saying with respect to COVID and the pandemic. Next slide. So that in terms of what the CDC guidance is essentially, as everyone knows, or many of you know, I think everybody probably knows, the guidance that was issued in mid-May by the CDC, it sort of was a game changer in terms of their pronouncement. And what they indicated initially is some updated guidance with respect to individuals who are fully vaccinated for COVID-19. And what they defined as being fully vaccinated for COVID-19 is someone who is 2 weeks or longer after the Pfizer vaccine or the Moderna vaccine in a 2-dose series, so after the second dose, or greater than 2 weeks after receiving a single dose vaccine of the Johnson & Johnson vaccine. There is currently no post-vaccination time limit on the fully vaccinated status. That aspect of the CDC guidance could change if there are updates from the pharmaceutical companies with respect to the efficacy of their vaccines, and there has been some talk about whether or not you would need to have a booster shot 6 months, 12 months down the road. But right now, the CDC guidance is once you are 2 weeks post a Pfizer or Moderna second shot, or a Johnson & Johnson 2 weeks post after that, you are considered fully vaccinated. One aspect to note with respect to the CDC guidance and vaccines is there's limited data right now in terms of whether or not this vaccine provides any meaningful protection for those who might be immunocompromised. And logically, that makes sense if they have an immune system issue to begin with. The vaccine, in terms of teaching the immune system in terms of how to respond to a virus, might not work. And so that is the guidance or the caution from the CDC from that aspect. Next slide. From the sort of the big takeaway from the CDC guidance is that according to the CDC, fully vaccinated people may now resume activities without wearing masks or physical distancing, except, and that's where I'll spend a little bit of time talking about what OSHA says, but except where required by federal law, state law, local, tribal, or other rules and regulations, or specific business or workplace guidance. They also indicated that domestic travel, there would be no requirement for testing before and after travel or self-quarantine after travel for the vaccinated. There's no such testing requirement for international travel as well. There's also no requirement for testing following, that is for COVID, following a known exposure to someone else with COVID if asymptomatic, with some exceptions for specific settings. And the exceptions are employees in detention facilities or correctional facilities. So if you're in the audience and that applies to you, then note that particular exception. There's a refrain from quarantine following a known exposure if asymptomatic, refrain from routine testing if feasible. In other words, before, or certainly earlier on, it's legit to require or to have employers or allow employers to test employees for whether or not they have COVID. And as a routine screening part of the workplace, and with respect to what the CDC is indicating, that's shouldn't be required if you have been fully vaccinated. Next slide. According to the CDC, though, be aware that if you are for fully vaccinated individuals, they should still continue to be tested if experiencing COVID-19 symptoms. So from that vantage point, certainly 3 weeks ago, many employers, and certainly all employers, should have had some protocols in place with respect to encouraging or maintaining a safe work environment for purposes of COVID-19. And often there would be a list of what the COVID symptoms are. And next slide. And in terms of what the COVID symptoms are, if someone, even if they have been vaccinated, is experiencing the symptoms that are on this list: fever or chills, cough, shortness of breath, fatigue, muscle or body aches, headache, new loss of sense or taste of smell, sore throat, congestion, nausea or vomiting, and diarrhea, that these individuals may have COVID-19. And so those would be situations where that individual, if it would appear to be one of those symptoms that are otherwise unexplained, that they should be subject to testing for COVID per the CDC. Next slide. In terms of CDC guiding principles for the fully vaccinated individuals, again, indoor and outdoor activities pose minimal risk to fully vaccinated people. Fully vaccinated people have a reduced risk of transmitting COVID to unvaccinated. Again, they should still get tested if they're experiencing COVID symptoms. They shouldn't be visiting private or public settings if they have tested positive for COVID in the prior 10 days or experiencing COVID-19 symptoms. And they would also, of course, need to continue, from an employer perspective, continue to follow, or other businesses generally, continue to follow any applicable other laws and regulations. And next slide. With respect to OSHA and why the CDC guidance was quite significant to what they had on their website literally 3 weeks ago. Their guidance before the CDC came out with its updated guidance with respect to vaccinated individuals in mid-May was that vaccinated individuals and then the unvaccinated need to be treated exactly the same. They must all wear masks. They must all socially distance, et cetera, and have all of the same protections in place. Since, however, the CDC issued its updated guidance, OSHA then updated its guidance and indicated that it was planning to update its guidance to be consistent with what the CDC is saying with respect to those who have been vaccinated for COVID. And so for the vaccinated worker, that an employer should go ahead and refer to what the CDC is saying. And if you do, you would be compliant with how OSHA is looking at it from a federal legal obligation standpoint. And so that's sort of what is on that slide. Next slide. One thing to keep in mind with respect to this is, and this is just the snapshot in May. And this is just the snapshot in May with respect to OSHA COVID inspections and investigations. And what this shows, and when there's a federal summary and a state summary, all that means is approximately 28 states in the country are federally run OSHA programs, and the remaining are state-run programs that are enforcing federal OSHA standards. And so that's why they're basically an approved state plan under the federal plan. And so that's why they list, and OSHA does track both because they're enforcing the same standards. And so for the month of May, what this shows is that OSHA, either through its federal agencies in those states where it is simply federal or in the state-run programs, opened up in excess of 330,000 separate referred, I should say, over 330,000 complaints that it then did an initial inspection or review in terms of alleged unsafe workplaces at employers from a COVID standpoint. And then the referral numbers are the numbers where they found, yes, we think there is a concern. And so they have referred it for on-site, presumably on-site investigations of the employers. And they do it on a weekly basis. And so as you can see, post the CDC guidance, there are approximately 20,000 such referrals of different employers that OSHA is investigating in terms of compliance with its regulations and safe workplace. So that's just something to sort of keep in mind, that when the CDC issued its updated guidance with respect to the vaccinated, there are still rules that apply to those who are not vaccinated. And it only becomes an issue until it becomes an issue. But this snapshot, which is something that's available on the OSHA website and that is regularly updated on a weekly basis, is something that employers should be cognizant of. Next slide. And then in May of 2021, approximately 13,000 of the investigations that were referred, so probably the majority of the number that were referred, or many of them, for the month of May, are death-related or catastrophe claims related to COVID-19. And so what that means is a situation where an employee alleges that he or she contracted COVID in the workplace. That complaint made its way, or allegation made its way. It might have been through a report by the employer, or it might have been a report, consistent with the reporting obligations for potential work-related situations, or it may have come in from the employee. But that's something also to sort of keep in mind as we go forward, that while, yes, the CDC has dramatically updated and nicely updated its guidance so that those of us that are vaccinated are certainly a lot freer, that one should be aware that ultimately the CDC is a scientific body, and then ultimately the issue is whether or not the federal government or the federal agencies, Department of Labor, OSHA, decide to enforce those regulations or guidance, and how they decide to do it, and then of course what the various state and local governments decide to do. Next slide. So just so that this is still on OSHA's website, and for those of us that are in Ohio, it's something to be particularly mindful of. And again, it only becomes an issue until it becomes an issue. But what OSHA is telling employers for the unvaccinated is that for the unvaccinated, they should be wearing face coverings. They should continue to be maintaining social distancing. That the department, for example, in Ohio or whatever state, but the Ohio Department of Health order does not somehow supersede or lift that requirement, because OSHA, of course, is not enforcing the state Department of Health order, but is enforcing its own regulations. Additionally, OSHA is recommending, although clearly they are to be consistent with the CDC, so I think there's going to be a lot of vagaries from that vantage point, but their recommendation or stated requirement on their website is that individuals at the workplace should be required to wear a face covering unless they're under the age of 2, consuming food or beverages, or are vaccinated. And then they have the same description for face covering that we've known. A face covering is something that covers the nose and mouth. For the unvaccinated, again, this doesn't apply to the vaccinated, but for the unvaccinated, wearing a face covering is still required, and they should also still stay 6 feet apart from others. And certainly as well, and this has been sort of if you've tuned into some of our other webinars earlier, certainly even for the unvaccinated, I mean, if there's a situation in the employment setting such that, look, it's such that we can't require them to wear face coverings, or we can't for the unvaccinated, because it may increase the risk of heat-related illnesses or outdoors, then clearly you can make appropriate exceptions for that situation. And certainly I would also say that if you have a situation where you are very confident that the worker is going to be far greater than 6 feet from anybody at any given time, what is reflected in this slide is what Osha is saying and its current guidance on face coverings for the unvaccinated. If that becomes a big issue in the employment setting as well, that's something that you can reach out to us. This is something that could change, but this bullet point, the last one, is still what's being indicated by Osha for the unvaccinated. Next slide. This slide here talks about generally the requirements that the employers are required to comply with the general duty clause, sort of the requirements that were in the earlier slide. These are some of the specific standards that govern these specific requirements. You have a workplace coordinator responsible for COVID issues in the employment, do a hazard assessment, identify the measures to protect and limit the spread of COVID. Obviously, they are following the CDC guidance for the vaccinated. So if you do have a workplace where everyone's vaccinated, then all of these OSHA requirements essentially don't apply to your workforce. But if you don't have that, you need to be mindful of that to the extent that you have individuals who are not vaccinated. Also consider the protections for workers at higher risk for severe illness, older people with immune compromised issues, and certainly be aware of those that may be entitled to reasonable accommodations. Note that however this is being communicated, it should be communicated in a language that the workers understand. Next slide. Also, and this is certainly consistent with what everyone is I think doing. OSHA is simply indicating that COVID-19 vaccines or vaccine series should be made available at no cost to all eligible employees. Note that from OSHA's standpoint, if you require a vaccine of an employee, mandate it, and they have an adverse reaction as a result of it, OSHA's position is that becomes a work-related condition. So just be cognizant of that. And then with respect to the other bullet points, are other bullet points that would be applicable to assuming that you have unvaccinated in your workforce. Obviously, if you have workers who show if you have COVID symptoms, even the vaccinated should be tested from that vantage point. They're still recommending the enhanced cleaning and disinfection. And again, that's presuming that you have unvaccinated individuals that are still in your workforce. Next slide. In terms of just general liability exposures and related considerations, just while again we seem to be leaving the pandemic, which is all good as more and more get vaccinated, but do understand that there are actions that are being brought, third-party actions based upon theories of premises liability and tort. Certainly OSHA whistleblower claims, OSHA regulatory violations, which was one of the other charts, workers' comp liability, sort of the key for most states with respect to the workers' comp liability piece is you just want to make sure that your employment setting is not any more dangerous than employment in general or than the public at large. And as long as you meet that test, you're probably going to be more likely than not okay when defending a COVID claim, because there is a little bit more that would need to be proven than a but-for clause. Employer intentional tort liability considerations, wage and hour, and other employment considerations, which will be discussed on by Debbie and Nancy. Next slide. One thing that you should be aware of, from sort of a business standpoint, and there are approximately 30 other states that either have similar laws in place or have pending legislation that's in place, and that is from a business standpoint. For customers, Ohio and many other states do have qualified immunity that is granted to you for the business for the public at large. So in other words, unless you willfully expose or recklessly expose customers to COVID and that's how they contract it, simply being negligent is not going to give them rise to a cause of action from this vantage point, which is, I think, great from the vantage point of protecting employers. But also note that unless extended, this immunity ends on September 30 of 2021.
Okay, great. Thanks, Scott. Appreciate that. I'm going to talk, it's Nancy again. I'm going to talk just a little bit about some of the litigation we're seeing in the vaccine area. Fortunately, this has been relatively limited, and I think it's going to be relatively short-lived. Could be wrong about that. But the litigation that we're seeing in some cases is arising from the fact that the vaccines have the status of emergency products. As many of you may be aware, they haven't gone through the full FDA process to be approved. And so therefore, because they're designated for emergency use, some employees have raised that sort of regulatory issue as a reason why employers should not be requiring them to get vaccinated as a condition of employment. Now, I will tell you in our survey, what we found, and it was consistent with kind of what my anecdotal experience has been, only 5% of the employers who responded to our survey had a requirement for mandatory vaccination of their employees. So I think that mandatory vaccinations are fairly rare at this point. That could change over time, but right now that's where it currently stands. The biggest lawsuit that you've probably heard of is the one out of Houston. Employees are suing Houston Methodist Hospital, where they are requiring, as they've required other types of inoculations and immunizations for their healthcare employees. There's a group, I think it's 1% of their employees are not vaccinated at this point, and they have brought an action saying that the requirement to get this vaccine, which has only gotten emergency authorization, is a violation of the principles of the Nuremberg Code, which was established in response to Nazi human experimentation with concentration camp victims. So they're sort of relying on that piece for purposes of saying that this is an illegal requirement from their employer. There are at least 3 other lawsuits that are bringing similar types of claims against various employers who, again, are requiring vaccination of their employees. The Los Angeles Unified School District. There's a suit against a sheriff's department in North Carolina, as well as a detention center in New Mexico. And there are a number of interest groups, and maybe some of you have received these. I have had clients who've received demand letters or threats of litigation because they're saying that the employer, for whoever it is that they're representing, is coercing or influencing or discriminating or requiring their employees to get vaccinations. For my clients who've received these letters, they are not doing mandatory vaccination. They might have slightly different rules for people who are vaccinated or not vaccinated. They might be asking questions about someone's vaccination status, which Debbie's going to talk a little bit about. But you may, as time goes on here, you may get a letter like that. And in some cases, I have had clients who basically just ignored them because they don't have any basis. Others have prepared some sort of response to disabuse the person who is sending the letter from the notion that they are requiring their employees to be vaccinated. In general, employers do have the ability to set these rules in their workplace about whether or not they're requiring employees to be vaccinated, of course, subject to the accommodation issues, which Debbie's going to talk about, and of course, subject to if there are specific state or federal laws or collective bargaining agreement, which would stand in the way of such a requirement. But workplace vaccination mandates have definitely been commonplace, especially in the healthcare industry, for years. And the EEOC has confirmed absolutely that employers are permitted to require workers to get the vaccine, again, subject to reasonable accommodations due to a health condition or religious belief, and Debbie's going to talk a little bit about that. So the argument that is going on in this litigation has to do, again, with the US FDA's sped up procedure for providing emergency authorization. And so therefore, those rules refer to the products as being, quote unquote, unapproved. And so this litigation is largely based on the idea that individuals have the option to refuse to get those vaccinations because they are unapproved. And there's no court case or government agency ruling that addresses this, so it's unclear sort of what is going to be the outcome of this litigation. One of the things that is going to impact this likely is just sort of the timing of the whole thing. As many of you know, Pfizer and Moderna have both applied for full authorization from the FDA. Most people think that'll happen probably August, September timeframe. Johnson & Johnson's a little bit farther behind, but it seems pretty clear that by the time this litigation actually comes to a head, all of these vaccines are probably going to have full FDA approval. The way that some of these cases have been brought is kind of typical employment litigation. People are bringing claims based on wrongful termination, termination in violation of public policy, which is a notion that is available in many states in terms of bringing a wrongful termination claim. So that's the basis for a number of these claims. And so certainly if you have a mandatory policy in place and you are considering taking adverse action against an employee for not getting vaccinated, there's certainly the possibility that you're going to face litigation. But my personal belief is that a lot of this is going to go away in fairly short order and is not really going to be a significant issue for most employers. All right, I will turn it over to Debbie to talk about vaccines and accommodations.
Thanks, Nancy. So yeah, we'll get right into talking a little bit about the vaccines, requirements, mandates, and accommodations. So let's jump right into the next screen here. Of course, you know, the fact that employers can require vaccinations is rooted in the guidance that the EEOC came out with when the vaccines came out. Declaring that COVID-19 vaccines are not medical examinations. So they're not prohibited as medical inquiries under the ADA, and nor are proof of vaccine requirements, which is even more important given the recent guidance from the CDC on the mask mandate and the elimination of masks for fully vaccinated individuals. So employers can require proof of vaccine. They can require a copy of the vaccine cards. Next slide. What employers still need to be cautious about, though, is making sure that they don't receive information about pre-vaccine screening. This is information that's likely to elicit disability-related information because, you know, when you go in for your vaccine, you're asked questions, asked to fill out that form that asks about prior allergic reactions, other conditions that may not be conducive to obtaining the vaccine. So that type of information is likely to fall within the scope, or does fall squarely within the scope of a disability-related inquiry that's regulated by the ADA. So next screen. With regard to pre-vaccine screenings, then if the employer obtains that information, and let's go to the next slide. If the employer obtains that information, they must show that they're obtaining it because the screening is job-related and consistent with business necessity. Now, this really only comes up if you're an employer who is conducting on-site vaccination clinics, you're continuing to do so, and you're engaging in that pre-vaccine screening. A way out of falling within that concern is one, having voluntary employer programs. That way, if they're offered on a purely voluntary basis and there are no consequences for refusal, then you're not making that disability related inquiry. And also employers can avoid the screening trap by just having third-party administration. So you either have the program conducted at your site by a third party, or you simply just request or require that your employees provide proof of vaccination, but are not conducting those vaccinations on site. If you are requiring, or even though that you may require or ask about vaccines, you are still going to have to be cognizant that you may have to make some reasonable accommodations with regard to the vaccinations. And let's go to the next slide. So employers are free to require COVID-19 vaccines, but there are a couple of ways that you may still have to provide accommodations with regard to that vaccine policy. The first type of accommodation comes under the ADA. So if you have employees who have disabilities that prohibit them from obtaining that vaccine, you're going to have to engage in the interactive process and determine whether you can accommodate that employee. And under Title VII, if there are employees who have sincerely held religious beliefs that prohibit them from getting the vaccination, you're going to have to accommodate that as well, unless it poses an undue hardship on you as an employer. Next screen. So if an employee is unable to receive the vaccine due to a disability, then you first have to take a look at whether they pose a direct threat to the health or safety of others in the organization and determining what to do. So look at things like the duration of the risk. Is this some short-term condition that they'll be able to get the vaccination maybe in a month or two, and perhaps you could put them on unpaid leave for a period of time. Look at other factors like the nature and severity of potential harm, the likelihood of harm, and the imminence of harm. So are you talking about an employee who works on a manufacturing line very close to other individuals so that they may be creating a risk? Or are you talking about an employee who works in a cubicle by himself or herself, or maybe even continues to work remotely? So those are all factors that you would have to look at to determine whether there is a direct threat to health or safety. Next screen. The next factor that must be considered then is if the threat can be eliminated or reduced by the reasonable accommodation. So is there a direct threat to the health or safety of the employee or others, and can it be eliminated or reduced by reasonable accommodation? And you're going to have to engage in the standard interactive process here. The EEOC has said that there are a number of things that can be done to provide accommodations for individuals who may not be able to receive the vaccine. You can provide perhaps increased protection by plexiglass barriers, if possible, relocating their workspace, distancing measures, other things that might create a reasonable accommodation. And remember, go back to the factor and look at the, remembering Nancy's slides on the fact that a lot of employees are enjoying working from home and maybe asking for a work from home accommodation because they can't receive the vaccine. That's not necessarily required. You don't have to provide the employee with the accommodation they request. So if there's something else that you can do, then that will be reasonable as well. Next screen. With regard to the religious objections are assumed to be sincerely held. So if you doubt that, you really have to have some objective basis for questioning the employee. The fact that an employer might just disagree with the employee's beliefs is not sufficient. If the employee just suddenly has adopted some new religion, or you have proof of that, that might be a way, but it has to be some objective basis. Next slide. However, just personal choice objections do not require an accommodation. Someone is just anti-vaccination or is uncomfortable with receiving the vaccine in any way, that does not create an obligation for you as the employer to provide an accommodation for them. Next screen. I want to quickly just touch on continuing considerations for COVID-19 vaccination programs. As more and more folks are returning to work, employers are continuing to wrestle with whether to make the vaccine mandatory or voluntary. And again, employers can require those vaccines as long as they're considering accommodations that may be required. Next slide. But for employers who are still looking at requiring mandating vaccines, do consider that that likely puts the employer on the hook for things like workers' compensation issues. If the employee becomes ill due to a mandatory COVID-19 vaccine, that may support a workers' comp claim, for instance. There are wage and hour considerations, so time spent receiving the vaccine, if it's required, is going to be compensable. Mandatory vaccines also should be paid for by the employer, just like you would for pre-employment physicals or drug tests. Next screen. But also consider for mandatory programs that if you're a union shop, you're gonna have to take a look at the CBA and see if it provides express authorization for vaccine programs. And if not, that would trigger a duty to bargain with the union before implementing a mandatory program. And the biggest consideration, of course, is employee relations. You may have a high population of employees who object to the vaccine based on personal choice. If you're mandating it, then you have to decide what you're going to do with big blocks of employees who are deciding that they're not going to receive this. And I think that's why most employers seem to be gravitating toward a voluntary program. Next slide. With voluntary programs, if you're encouraging but not requiring the vaccine, that certainly eliminates concerns from a wage and hour perspective, a workers' comp perspective, also neutralizes those EEO considerations. Next slide. But you do need to consider balancing that with OSHA or other state health requirements. So if you have state or federal or local law that requires vaccines in certain areas, certain geographic territories, or certain industry spaces, then that's going to override this decision, obviously, about whether to make this a voluntary program. And because nothing in employment law is black and white, if it's a voluntary program, you still could have some workers' comp issues if non-vaccinated workforce populations increase the risk of spread of COVID-19. So never a clear answer on any of these things. Next slide. Most important thing is, as you're returning your folks to work, just make sure that you do have a very clear vaccination policy, that you communicate the company's position, that you have a clear explanation of what you expect and what the procedure is. Make sure you have a point person who can provide the information and also channel any of the accommodation requests. And certainly make sure that you are including the EEOC protective provisions in your written policies with regard to vaccination programs. Next slide. That accommodation issues come up with regard to the vaccine, but they're also coming up with regard to just reopening and bringing employees back into the workforce. So one question is, as you bring more employees back, may you ask employees with disabilities to notify you in advance if they believe that they may need accommodations when they come back to work. That's okay. You can make those requests in advance so you can start that interactive process, start sorting through what additional obligations or requirements that you may have. But bear in mind, of course, that if an employee does not respond to that request for information prior to coming back, and they come back to work and then they make a request for an accommodation, you're still going to have to process that as you would any other request for a disability-related accommodation. Next slide. There's been some concern from employers about whether pandemic telework has set a precedent for post-pandemic requests to work from home. And the EEOC has said, no, that's not the case. Anytime you as an employer receive a request for a reasonable accommodation, you are still entitled to understand the disability-related limitation that requires that accommodation. So to the extent that you may have permitted telework to employees because of COVID-19 and trying to keep the workforce safe, that doesn't mean you have to continue offering telework as a reasonable accommodation if it requires continuing to excuse the employee from performing an essential function. So there is no disability, if there's no disability-related limitation that requires teleworking, then you're not going to have to provide telework as an accommodation. It doesn't set a floor just because you did it before. There are also a lot of issues under ADA accommodation categories based upon anxiety or mental health issues. So clearly we were all stressed by the pandemic, but certainly individuals who have certain mental health conditions, anxiety disorder, obsessive compulsive disorder, post-traumatic stress disorder, they may have had more difficulty in handling the pandemic and continue to do so. So just remember that those types of requests, again, are just like any other questions or requests for accommodations based upon a disability. You are free and should ask questions to determine whether the condition is a disability, to request the medical documentation that you need to evaluate it, to discuss with the employee how the requested accommodation would help them, and certainly, again, have the continued ability to explore alternative accommodations that may effectively meet the employee's needs. I want to transition to a different topic now with regard to continued remote work, and Nancy touched upon the fact that it's more and more popular for both employees and employers. But there are a couple of things that you really need to keep in mind with regard to an increased population of remote employees. Jumping to the bottom of this list first, there are certainly state-specific payroll issues and even local payroll issues. So you have a lot of people. Nancy referenced that many people have moved farther away. Some people are working from remote locations vacation homes in other states. Some people are traveling. They are, spending a month at a time in different locales and working from there. And you really need to have a policy in place for understanding where your employees are actually physically working, because you may be required to have different withholding. You may have different requirements with regard to separation and payout of their remaining payroll at the time of separation. So keep a handle on exactly where employees are performing their work for you. And certainly the remote workforce brings new challenges with regard to trade secret issues and security concerns. It's really changed the landscape there. Next slide. Certainly some things have not changed. You need to continue to follow the trade secret protections that you do, identify what your trade secret information is, limit access, make sure you're using methods to protect that information, like having secure logins, passwords, firewalls, that types of things. But with the remote workforce, additional measures are necessary. You have folks who are now working from their office or from Starbucks or from a hotel or an Airbnb somewhere, and that changes the game. Next screen. Certainly that means that they're working with other people perhaps in that place. You don't have as tight a control over who may be sitting next to them. Certainly you don't have as tight a control about what they're doing with your information when they're finished with it. And you have folks who are accessing your servers and your information from remote locations, oftentimes from personal devices. So make sure that you are implementing security measures for those remote locations. Require minimum home security measures for the employees' home internet networks or those networks wherever they are performing your work from. Make sure they are using Wi-Fi passwords with those remote locations, and consider utilizing multi-factor authentication in order for them to log into the company portal. Next screen. Should also consider in some cases whether you want to implement monitoring policies for a population of remote workers. Once again, workers are becoming more mobile. There are a lot of options. They're looking at different workplaces with regard to increased flexibility, and that may compromise your information. So you might want to start routine monitoring of use of information. If employees just on a periodic basis have IT take a look at what kinds of documents they're getting into. You may want to set up some suspicious use monitoring. For instance, if somebody's looking at 100 different documents in a day, when they are typically only looking at 1 or 2, that could trigger that they are trying to harvest your information, and you might want to have a system in place for monitoring that. Could also put red flags in place for when employees tap into certain key data. So your most sensitive data, anytime that someone takes a look at that data, you could get a notification and then determine whether that's an appropriate use or not, and whether you should investigate that. Next screen. Some other policy considerations that you should consider: certainly review and update your handbook with regard to remote work policies. Make sure it is addressing things like, are they permitted to use personal devices? Making sure that if they do, that you have policies in place that allow you to periodically review their devices. Maybe require that they do not use any kind of electronic storage devices, or that they notify you that you have some security in place around that. Certainly make sure that you have updated your confidentiality agreements to address the use of your information. These are going to be more important than ever as employees are using this information. Next screen. Renewed training is also key. So you want to generally remind employees of your policies and your security protocols and your updated security protocols. Retrain employees remotely on the importance of your non-disclosure and your confidentiality policies. Certainly remind and expressly advise in a written policy your remote workers that when they're working on your information, they're doing work for you, they should be doing that in an isolated part of the home. They should be doing that in a separate office, in a separate location from others, even from their family members. Because remember, if you're talking about trade secret information, you try to take action to protect it, you have to show that you took reasonable steps to protect the secrecy of that information. So if they are allowed to sit at the kitchen table with their roommate or their neighbor or their spouse, and that information is laid out for all to view, that could compromise the integrity of that information. Jumping down to the next bullet, you need to remind and train employees who are using video conferencing services to use those services security features and your own established security. Case in point, there was a litigation from last summer in which a preliminary injunction was denied to a franchise operator because the franchise operator was freely allowing potential franchisees to jump on Zoom calls in which they communicated what they considered to be trade secret information, but they were not following Zoom security procedures. They were not using password protection. They did not try to ascertain who was on the call. So you're having all these web-based platforms and technology that you're utilizing for your meetings. Make sure you're using those security features, or again, you could be compromising the integrity of that information. So very important that you make sure your employees understand the new remote work landscape. And with that, I will pass it on to Hannah.
Thanks, Debbie. So as you may know, Congress has extended the FFCRA payroll tax credit through September, but there are some new wrinkles that employers should consider. So by way of background, last year, the FFCRA required many employers to offer COVID-19 related leave between April 1st and December 31st in 2020. And that law applied to employers with less than 500 employees and included two different types of leave. First, 2 weeks of paid sick leave at either full rate or 2/3 rate, depending on the reason. And second, paid childcare or family leave for 2 weeks unpaid and up to 10 weeks at full rate. And the FFCRA expired on December 31st, 2020. So beginning in January of this year, the Consolidated Appropriations Act of 2021 gave employers the option to provide this FFCRA leave voluntarily and to take a payroll tax credit to cover wages paid through March 31st, 2021. Which brings us to now and the latest COVID-19 relief law, which is the American Rescue Plan Act of 2021, which further extends the payroll tax credits for voluntary paid leave to September 30th of this year. But there are some key changes. Importantly, the tax credits are now available for providing paid leave for the reasons in the FFCRA, in addition to new qualifying reasons, including absences related to receiving the COVID-19 vaccine. So, a qualifying reason, the additional reasons are if an employee is obtaining the COVID-19 vaccine, is recovering from an illness or condition related to the COVID-19 vaccine, or if the employee is seeking or awaiting the results of a COVID-19 diagnosis test because either they were exposed to COVID-19 or the employer requested the test or diagnosis. Some additional changes are paid sick leave is reset under the Consolidated Appropriation, under the ARPA. While the December stimulus bill simply allowed employers to claim a credit for paid leave to the extent the employee had not previously used their initial 10-day allotment, the ARPA permits employers to claim a tax credit for an additional 10 days of emergency leave between April 1st and September 30th of this year. There are also new non-discrimination rules. The ARPA expressly provides that an employer who extends emergency sick and or family leave to some employees, aka highly compensated employees, full-time employees, or tenured employees and not others, cannot claim the tax credits for the leave wages paid. And finally, there's an increased cap on expanded FMLA dollars. So the FFCRA, as enacted, capped the amount of paid leave wages for which employers could claim credit at $10,000 for employees, and the ARPA raises that limit to $12,000. Next slide. Thank you. So some employees have had questions related to leave allotments under the ARPA as applied to fully vaccinated employees. And as Debbie and Nancy mentioned before, the CDC says that fully vaccinated individuals are not exempt from employer-required safety protocols, but they may refrain from quarantining and testing following a known exposure to someone with COVID-19, so long as they have no symptoms. Next slide, please. So that brings us to a predicament. the ARPA does not differentiate between leave entitlements for vaccinated individuals versus unvaccinated individuals, but obviously the CDC does. So while a significant portion of employers have chosen to provide voluntary leave, and the tax credits make the decision to extend the FFCRA more attractive, there are other considerations that may weigh for or against extending the leave. So the incentive is that the additional tax credit benefits can complement an employer's existing leave policies. And moreover, employers who are voluntarily providing leave for COVID-19 reasons can utilize the expanded eligibility categories to reinforce their vaccine incentive programs for employees. But the disincentive, on the other hand, is that the reasons a fully vaccinated individual can still take leave under the ARPA are at odds with CDC guidance. While the CDC clearly says that no quarantine is required after exposure for those who are fully vaccinated, the ARPA says that fully vaccinated individuals may still take paid leave following exposure. And so these considerations are employer specific, and given the nature of your work and your workforce, the number of employees who are expected to have qualifying needs, and the risk that employees will work when they may be exposing others to avoid financial hardship are some things to consider. Next slide, please. So moving on to a different topic, the question of whether employers should compel their workforces to be vaccinated against the coronavirus is rippling through the country. And given increasing availability of the COVID-19 vaccine, a lot of states are considering legislation intended to prevent employers from mandating vaccines. So as background, just a quick recap. As Debbie and Nancy mentioned, we know that per EEOC guidance, private employers can require employees to get vaccinated for COVID-19 as long as they comply with federal employment laws that prohibit discrimination on the basis of religion and disability. But employers have no obligation to accommodate employees who refuse to get vaccinated because of personal choice. Next slide, please. So that brings us to state anti-vax discrimination statutes. Lawmakers in over 40 states have proposed legislation that would allow unvaccinated employees, regardless of protected status, to bring claims against employers who treat them differently. And the proposed legislation varies widely by states in terms of who would be shielded from mandatory vaccinations and under what circumstances. For example, some legislation would prohibit employer-mandated vaccinations outright. Other legislation would permit mandated vaccinations only for employees who work in a healthcare facility or with medically vulnerable populations. And finally, some would expand the federally recognized religious exemption to include philosophical objections or objections of the conscience. Next slide, please. So nearly every bill pertaining to the rights of current or prospective employees prohibits employers from making vaccination a condition of employment or taking adverse employment actions based on the employee's COVID-19 vaccination status. And further, a few bills propose to extend protections against mandatory vaccinations beyond the employment context. In these states, public entities, and in some cases even private businesses, would be prohibited from denying entry or refusing to provide goods and services to individuals who have refused vaccination. For example, in Texas this week, Governor Abbott signed a law banning Texas businesses from requiring vaccine information. And under that law, businesses requiring so-called vaccine passports can't get some state contracts and could lose state licenses and operating permits. While more sweeping bills are unlikely to become law, some states like Montana and California have approved or are considering approving employers to require proof of vaccination before workers can stop wearing face coverings and abiding by social distancing rules. And finally, in light of all of these legal and logistical challenges, it's important to note, as Nancy and Debbie did earlier, that business-wide vaccine mandates have been rare, leaving most workplaces mixed with vaccinated and unvaccinated employees. And with that, I'll turn it back to Nancy.
Great, thank you so much, Hannah. So thank you so much, everybody who has remained with us through the first hour and I guess 18 minutes. We have gotten some good questions from some of our participants. I'm not sure if we'll be able to get to all of them, but we're going to work our way through a number of these questions before our time is up today. So I will ask Scott, we have a question about OSHA reporting requirements, and Scott is our resident OSHA expert, so I will see if he would be willing to read that question to the group and provide a response. And Scott, you might still be mute. Okay, I don't know, he's still mute, so I'm going to try, I will answer one of the questions and we'll come back to Scott. There's a question here from a healthcare facility saying that they're an outpatient healthcare facility with multiple locations, but they're providing patient care. And they are asking both fully vaccinated employees as well as those who are not vaccinated to continue to mask. And the question is that an appropriate requirement since they are a patient care facility, or could someone challenge that mandate if they are in fact fully vaccinated? So, and I'll turn to my co-presenters if they have different thoughts than I do on that question. My thought is that you can certainly continue to require your employees to be masked, even if it is not required by the CDC currently. And I think particularly given the type of industry that you're in and you're providing patient care, that there's certainly a justification for that. Obviously, with any other requirement that you impose upon your employees, if you do have somebody who has a disability that prevents them from wearing a mask, you would have to go through the reasonable accommodation process with that employee to address their ability to wear a mask. And the other thing to kind of keep an eye on is there are some states and local rules being, or statutes or ordinances being considered that deal with masking and whether you can require people to mask. And so one thing that you would just want to assure yourself of with your different locations is to make sure that there is no applicable state or local ordinance dealing with the requirement to make people mask. So that would be the answer to that question. I think I see that Scott has his microphone on now, so I think I'll turn it over to him to see if he could respond to the question about OSHA recording.
Yes, no, I was having trouble finding the turn off mic mute button on my screen. So yes, the question, and before I get to it, I heard your answer, Nancy, to that question, and I 100% concur. The CDC sets sort of the minimum guidelines, but it's very clear that it's not saying that you can't require employees, even the vaccinated, to mask up. So I totally would parrot that. With respect to the question on OSHA, the question was, and it's a great question, I believe I saw something that OSHA was not going to make you record adverse reactions to the vaccine. So yes, OSHA did recently update its website to say that while 1904, which is the code provision that says if you have a work-related condition and it requires hospitalization, medical treatment beyond first aid, or death, it goes into your OSHA log, that they are putting on a hiatus of enforcing that requirement for an employer that mandates vaccines. What they are not saying is that doesn't mean that it's not work-related. It doesn't need to go into the log. So the other aspect of, just as a consideration, if you as an employer require your employees to be vaccinated and that employee has an adverse reaction, while OSHA right now would take the position that we're not going to enforce it going into the log, if that individual then turns around and files a workers' comp claim, claiming that, hey, as a condition of employment, you required that I get a vaccine, I had this adverse reaction, I had to be hospitalized, et cetera, et cetera, et cetera. The fact that it doesn't make it into an OSHA log does not, A, they're not saying it's not work-related, and B, it wouldn't preclude that claim from going forward. But it's a great question.
Fantastic. And Scott, I think there's another one for you dealing with contract workers who are on site. Do you mind answering that question about mask mandates, et cetera?
Sure. Yes. The other question is, can an employee of company A require that individuals on site engaged through a contracting agency mandate that company Z, in this example, mandate that the company Z employees wear masks and or get vaccine while on the company A premises? The answer is yes, you could require that they wear a mask, certainly, and or show evidence that they have been vaccinated from that vantage point. That would be perfectly legit. Certainly, if you do implement such a policy, you would have to sort of consider a case-by-case scenario in terms of potential accommodation if that's an issue. So that's something that if you have blowback from that, you may want to speak with legal counsel specifically. But as a general proposition, the answer to that question is yes.
Okay, great. Yeah, these are great questions. Debbie, here's a question for you. One of our participants asked if we could address laws in the United States that employers should consider if they are tracking which employees are vaccinated or who is not vaccinated. Do you want to take that question?
Yeah, sure. I'll answer that in a couple of different ways. So I think that number one, in terms of how you handle the information, certainly we go back to the EEOC guidance that says proof of vaccination is not a disability-related inquiry, is not a medical inquiry. But the guidance that I've seen certainly suggests that even with that, you should still be handling that proof of vaccination if you're requiring it as you would other medical information. So it should be kept in that separate medical folder and only be shared with folks who have a reason to know. With regard to tracking itself, I think that employers, as Hannah alluded to, we're going to continue to see more state and local legislation, I think, surrounding the requirement to track or the ability to track. So certainly make sure that you are looking at and keeping abreast of developments in the areas where you as a company operate. Generally speaking, certainly employers are requiring that proof of vaccination and are tracking that as people want to unmask in the workplace. And some employers have, are even implementing systems where they provide some sticker or a pin or something for employees who are allowed to unmask to wear so that it is easy to track them if you have a large location, for instance. But just a caution that in that type of circumstance, there still is going to be a need for accommodation issues. So not only would that information or that designation be provided to individuals who provide proof of vaccine, but also individuals who provide proof that they or provide information that they need an accommodation because they, for some reason, they cannot mask, whether that is a disability-related accommodation or a religious accommodation.
Okay, great. Well, and one thing too, I mean, this is just, again, something you hear people who don't deal in this area a lot talking about, or employees who don't want to reveal their vaccination status. They'll say it's HIPAA protected, you can't ask that. The vaccination card, that document revealing that information, that is not covered by HIPAA. So it's easy to think that it might be, but it is not. So all the rules that apply to HIPAA would not apply to that, but you still have the concerns that you would have similar to somebody who's requesting FEMLA leave and they're providing a certification from their doctor. It would be treated the same way, put in that separate, as Debbie said, that separate medical portion of somebody's personnel file and only shared on a need to know basis. So that was a great question. Yeah.
Remember that if employers are requiring the proof of vaccine in order for employees to have the privilege of unmasking, then they are voluntarily providing that information for the quote unquote privilege of not having to wear the mask in the workplace. So it's a voluntary process as well.
Correct. No, that's a great point. Okay, and I think we have time for maybe one more question. Scott, I'm going to throw this one over to you. We have a question, and maybe you could read it to the group, dealing with surveying employees about their vaccination status and criteria or resources that a company should be thinking about. So Scott, do you want to answer that question? We'll make that our last one.
Sure, yes. So this question asks, my company is considering sending out a survey to find out whether employees are vaccinated through an HR benefit survey so that will inform whether to eliminate the mask wearing once we reach a high enough percentage of fully vaccinated employees. Is this acceptable, or other criteria resources that we should consider before actioning? In fact, a great question. if this is to be done, would recommend that it probably, I mean, while you can ask, it's not a protected question to ask somebody whether or not they're vaccinated. You might do this as sort of a survey without requiring the individual to identify, but however you do it, that is certainly a perfectly acceptable way to go. That if you don't want your supervisors or people that are there to be mask police or measure or having to specifically control who is vaccinated, who is not vaccinated, social distancing, et cetera, and until you have a high enough percentage, just require everybody to be vaccinated. That is a perfectly legal approach, and certainly other employers are doing just that. So great question.
Yeah, and I think the key on those survey questions, obviously, is not to ask things. You can certainly ask. I know some employers are asking, if you are not vaccinated, do you intend to be vaccinated in the future? That question is probably not as relevant now as it might have been a couple of months ago. You just want to avoid, obviously, asking the question of, if you're not vaccinated, why not? Because obviously that's getting into a potential disability-related inquiry. So it is 2:30. I want to thank everybody for participating today and staying on the line for this long. Hopefully this has been helpful to you. Thanks to Scott, Hannah, and Debbie for their presentations, which were fantastic. Just want to remind everybody, we will be sending the slides out, as well as a recording of today's session. You should be getting that within 1 to 2 business days. And so please look for those materials in your email. If you have any questions that we were unable to get to today or that come up as you're thinking through the materials, please feel free to email or call any of us or your regular Thompson Hine lawyer. If you're not a current Thompson Hine client, feel free to contact any one of us and we'll discuss available options to address your needs. Thank you so much for attending and have a great day.